So I'm sure everybody has heard on the news stories about businesses refusing service to specific groups of people, most notably LGBT people. That's kind of what it has to do with my topic today. My main claim is that the legislation which allows people or businesses to refuse service to certain groups on the basis of deeply held religious beliefs is a violation of the separation of church and state. And the concept of separation of church and state has to do with the government needing to have an attitude of neutrality towards religion. So they can't promote it and they can't be against it either. And I'm going to support that proposition with three supporting claims. The first one is that it's not supported by the Constitution or by law. The second one is that it applies the moral absolutes of one religion to others who may not hold the same beliefs. And the third is that it has the potential to open the door for more extreme church-state entanglement. So my first claim is that it's not supported by law. Supporters of this type of legislation or behavior, they claim that they're protecting a right given to them by the Constitution or the First Amendment, more specifically. And you'll hear legislation or like proposed bills called like First Amendment Defense Act, or organizations called the Alliance Defending Freedom, that type of thing. And they're referring to the Free Exercise Clause, which states that Congress cannot prohibit the free exercise of religion. The U.S. Court's website defines that as the Free Exercise Clause protects citizens' rights to practice their religion as they please, so long as the practice does not run afoul of a public morals or compelling governmental interest. So like if you're doing human sacrifice, obviously that would not be protected. Practicing faith and using it to guide your own life is a right, as stated by the Constitution. However, when it becomes discrimination and it infringes on others' rights, it is not. Because it violates anti-discrimination legislation, like in Title VII of the 1964 Civil Rights Act, which prevents public facilities from discriminating because of such individuals' race, color, religion, sex, or national origin. So there was a case in 2014 called Hall versus BNSF Railway Company. And the company provided health insurance for opposite-sex couples, but not for same-sex couples. And the court ruled that they denied dismissal of this case because on the grounds of sex-based discrimination. So that's just one example of that. So not only does it is it not protected by free exercise, but it does also violate the Establishment Clause, which says that Congress shall make no law respecting an establishment of religion. Because of the Lemon Test, which was established in a case called Lemon v. Kurtzman in 1973, which establishes a three-pronged system, which is defined by the U.S. Court's website again. The three prongs are: the primary purpose must be secular, it must neither promote nor inhibit religion, and there must be no excessive entanglement between church and state. And this type of behavior does not follow these three branches, obviously. The whole purpose of these laws is to protect actions taken because of religious beliefs, so that's clearly not secular. I'll state this a little bit more later, but it indirectly promotes one religion while inhibiting minorities. And the no excessive entanglement thing is kind of harder to pinpoint. It's a little bit fuzzy, but I would argue that there is excessive entanglement with these type of behaviors. And that leads me to my second claim that this legislation and behavior that discriminates against certain groups of people applies the moral absolutes of one religion to a group that may not necessarily share those beliefs. So each religion has its own set of morals and rules. So like, you know, certain branches of Christianity want women to dress modestly. Muslims aren't supposed to eat pork, that type of thing. And a lot of religions have restrictions on sex, that type of behavior. And these restrictions don't apply to everybody. Morality is ultimately subjective. So, for example, I am an agnostic or an atheist, and my right and wrong comes from how my actions affect others. I'm not part of any religion, so it doesn't apply to me, those type of restrictions. It wouldn't make sense to enforce upon me something like that, just like it wouldn't make sense to force a Christian not to eat pork. Do you know what I'm saying? So it also puts minorities at a disadvantage because according to Pew Research Center's Religion and Public Life Project, 70.6% of the total U.S. population and 90.7% of the current Congress are some denomination of Christianity. So that's not a bad thing. It makes sense when you consider, you know, the demographics when the country was founded, but it must be considered because it means that somebody who wants these protections is most likely a Christian, and that kind of indirectly promotes Christianity above all others in a way. It indirectly promotes a specific religion's values rather than secular ones, and it also puts minorities at a disadvantage or inhibits them. So there's a sociologist named Jeffrey Victor, and he says, American society is the most traditionally religious of all industrial societies. One reason is that in American culture, the practice of religion, any religion, is socially encouraged as an expression of good citizenship. As a result, atheism and agnosticism are regarded as disreputable and informally discouraged as potentially immoral. So you can see how that would be, the establishment of one would be unfair to someone like me or someone that's not in part of the majority. And my third supporting claim is that it opens the door for more expansion and more policies like this. So like I said at the beginning, you've probably heard all the stories about like florists and cake, like bakers and people like that refusing service. And you see signs everywhere in businesses that say, we reserve the right to refuse service to anyone. And that's commonly seen in private businesses, and it doesn't seem all that problematic. But even that has been ruled in violation of things like Title VII in some cases. But federal employees have been doing it as well. I'm sure almost all of you have heard the name Kim Davis. She refused to provide marriage licenses after the Supreme Court decision on same-sex marriage was decided in 2015. And there are similar cases in places such as Indiana. It's the same basic concept as a public school teacher not being able to enforce religion, because that's a government official, and that would qualify as violating the Establishment Clause. But it could go even further, in bills such as the First Amendment Defense Act, which is a bill that's trying to get passed right now. And it says, this bill prohibits the federal government from taking discriminatory action against a person on the basis that such person believes or acts in accordance with a religious belief or moral conviction that 1, marriage is or should be recognized as the union of one man and one woman, or 2, sexual relations are properly reserved to such a marriage. And person is defined in the bill as also including businesses and corporations, which means that the government cannot interfere in discrimination cases like this by taking away like tax exemptions or federal funding, and they can sue, or these businesses can sue the government if they try to take action like this. Jennifer Pieser, Law and Policy Director at Lambda Legal, said, this proposed new law violates both equal protection and the Establishment Clause by elevating one set of religious beliefs above all others and by targeting LGBT Americans as a group, contrary to settled constitutional law. So the question is, what I'll leave you with is, how far will this go? Walter Olson in a Newsweek article said, consider, for example, a nursing home paid with federal dollars whose manager doesn't care to let Al in to visit Bob, though they have been legally married for years, because that would be too much like recognizing gay marriage. May officials in Washington at least move to cut off the future flow of Bob's Medicaid checks to the home? Under FADA, it's not clear that they may. So my final note would be that this type of discrimination is ruled as okay in these cases if it is based on strong beliefs or convictions, and there's no way to tell if that's sincere. Rather than protecting religious freedom, it is equating discrimination to religious freedom, and we don't know how far that could go. And so I hope that I have proven to you that this kind of legislation or discrimination because of religious views is a violation of the separation of church and state.
All right, I got to keep it quick because you did go 2.5 minutes over time. The proposition's clearly identified. There's a good preview of the supporting points. I thought your explanation on the first point was pretty clear. The second point was a little bit more problematic, and I think that that's where a lot of the argument lies. And you don't really talk about that as much until you get near the end of the speech when you've got a hypothetical example that you're using to illustrate your particular point. I think the hypothetical example fits, but of course a hypothetical example is always going to fit. We need more data to suggest that the government would be unable to respond if in fact government money was involved in the process. The argument that there is a contradiction or a problem with private groups doing this, you mentioned at one point that it has been, that people who reserve the right to refuse service to anyone, that has been prohibited by the courts in some cases. That's what we need more of. We need to know the kinds of cases where that applies so that we can tell whether or not the things that you're sort of suggesting are likely to occur are the ones that would be subject to these current rules. Part of what you're talking about is hypothetical, assuming this law passes. Part of it is talking about what's going on right now, and of course, everybody's ox is being gored. Your example about the your own situation suggests that there might be something that is potentially problematic about the way you would be treated. But I didn't understand where that was going. What sort of thing was going to happen? If a florist didn't want to serve you because you were an agnostic, then I could see that there might be an issue going on there. But you don't have any particular cases like that. It seems pretty speculative at this point. The only ones that you have are the ones that you're talking about that fall under, the proposed fix that they're talking about, and I think that you need to maybe talk about that a little bit more earlier in the presentation. All right, thank you.